please, Jen. Lovely. And skip the next slide. Lovely. So today's session is about programme generally. Thanks, Jen. So we're gonna have a sort of little mix of predominantly we're looking at NEC programming. There's going to be a little bit of JCT as well, just for information, but also comparison purposes with NEC. Obviously, we're looking at NEC 3 and 4. And then we're going to have a little bit of law at the end. So we're going to look at global claims, delay in contrast to disruption, and also, as it says there on the slide, clauses to be wary of. So if we can have the next slide, please. So the first little bit is on NEC and the programming requirements. I would say, well, we'll then contrast it with JCT and what JCT says about programming, but we can't do that because basically JCT says nothing about programming, or very, very little. And that's probably, fits in with the different types of contracts they are. So with NEC, as we would expect, it's pretty prescriptive. So we've got clause 3, which then translates into the 30s, so 31 onwards. And the first thing to note is clause 31.1, which says that the programme, so it's not, there's no option here, there will be a programme, or there should be a programme provided by the contractor, or in a subcontract, the subcontractor. So the programme is either appended to the contract, in which case it becomes the accepted programme. So that's your base programme for the works. That is my preference for contractors and subcontractors in subcontracts, because you have your base programme sewn into the contract and it is there. There can't be issues about whether it is the base programme or not. Obviously, you need to ensure, if you're the contractor or a subcontractor, that it contains all the relevant information that we'll be looking at. The other option is that it's included after the contract has been entered into, in which case contractor or subcontractor submits it to the project manager, or in the case of a subcontract, to the contractor for acceptance. So the contract data will state the timescales within which, don't know what you've done there, Jen, but we've now got lots of pictures of no slide.
Sorry, just give me a second, Sarah. I've just had a couple of messages to say that the screen's not sharing properly. So just
right.
Give me a second and we'll just try and figure that out. Sorry to stop you midway.
No worries.
So hopefully that should be okay now. If it's not,
then it's good for me.
An email over, but otherwise I'll let you get back to it, Sarah. Sorry about that.
Okay, no worries. Thank you. Yes, so it's got to be submitted by whatever timescale is set out in the contract data for submitting the first accepted programme. Usually it's 28 days. So then, as we'd expect with NEC, it's a prescriptive contract, so 31.3, then passes it to the PM, and the PM has to do something with the accepted programme. As you'd expect, they either accept it or reject it. They've got 2 weeks to do that, and there are certain reasons for not accepting the programme. So project manager can't just say it's not accepted. They've got to give reasons, and it's got to be one of the ones in the contract. So they're set out there that the programme isn't practicable. It doesn't show the information that it needs to show, so we'll see that later. It doesn't reasonably represent the contractor's plans, or it doesn't comply with the works information. Now, in my experience, when you get to a stage where the first programme cannot be accepted, you usually have challenges, shall we say, or problems on the project, which is why I prefer the programme to be sewn into the contract, so you don't start with these issues. And of course, a lot of these reasons are sort of, they're quite esoteric in a way, you know, it's not practicable, it doesn't comply with the works information. You know, it's all a little bit intangible, which is, you know, another reason why, you know, I prefer not to have this as, you know, an issue between the parties, because it does very much then, you know, taint relations. So with NEC, the programming isn't just right, well, we've got one sewn into the contract, or we've got our accepted program, that's it. If we can forget about it. So at 32.2, there's a requirement for contractors or subcontractors in a subcontract to submit revised programs. So in accordance with the project manager's request, if the contractor chooses to do so, and also at intervals stated in the contract data. So usually the contract data will say every 28 days or monthly. So if we can move on to the next slide, please. So it shows that this is very much a sort of developing issue, and it's to me, it's one of the best things about NEC, because at the end of the project, you should have a series of programs which show, as a matter of fact, what was happening on site at specific points in time. So based on the updates, the first bullet point says that realistically, the contractor will be submitting an updated programme at least monthly. In my experience, assuming that is complied with, then, you know, you will have a good set of programs. Also, the other usual time when an updated program is provided is when contractor or subcontractor is providing a quote for a compensation event, where they are requesting more time as well as money. So if you're requesting more time, the requirement is that you must submit an updated program to show to justify the time that you're claiming. So 32.1, revised programs must show project achieved on each operation and its effect on the timing of the remaining work. So that's probably expected. The effects of implemented CEs, so that's just for NEC 3, is a little controversial, because of course an implemented CE is one where the quote has either, so the time, the cost implications have been accepted, or the project manager has made its own assessment and it's been implemented. So of course that's usually at the end of the commercial process regarding the CE, so it doesn't reflect reality in the interim period between the CE arising and it being implemented. So that's now been removed from NEC 4, so that all sort of non-implemented and implemented CEs need to be included. Also, how the contractor plans to deal with any delays or notified defects, and other changes which the contractor proposes to make to the accepted programme. So, you know, again, really important to understand what needs to be included. Also needs to include float and time risk allowances. Just very roughly, my understanding is that the float is the bit at the end of the project, and that belongs to the contractor. The time, or the subcontractor, the time risk allowances are the surplus time through the contract, and that belongs to the project. So next slide, please. So yeah, some key points for contractors and subcontractors in subcontracts. So some of the dates that you need to include in your programme are these sub-bullet points. the reason that they need to be included is because whether or not the contractor stroke subcontractor gets a compensation event for delays to these issues depends upon this information being in the accepted programme. So if it's not in the accepted programme, there's a good chance that if the dates aren't met, and typically they're dates to be complied with by the paying party, by the employer or the contractor and a subcontractor, if those dates aren't in the accepted programme, the contractor can't measure it against the actual date of provision and therefore wouldn't be entitled or wouldn't succeed in a claim for a compensation event. So that's why the programme is important to contractors and subcontractors. So the kind of the bullet points at the bottom, kind of 4 bullet points are the compensation events that those items relate to. So as I say, really important, contractors and subcontractors, that you include that information in your accepted programme. Next slide, please. So clause 62.2, I'm sure you know this already because we pretty much cover it every month, but your quotation for a compensation event, not only must it include the money side of things, but also any extension of time to your completion date, contractors and subcontractors, and of course any financial impact to any delay. So bear that in mind. So the next 2 bullet points are just to note anyway. 63.3 and NEC 4 clause 63.5 sets out the criteria for delay. So a delay to the completion date is assessed as the length of time that, due to the compensation event that we are discussing, the planned completion date is later than the completion date shown on the accepted programme. And similar assessment in NEC 4 for key dates. And finally, at 64.1, we talked about if you're making a quote that includes an extension of time, you need to include a new or a revised programme to show that delay. So 64.1 states that the project manager has grounds to make its own assessment and therefore reject the quote if when submitting the quote, the contractors failed to submit that revised programme or details of the alterations to the programme. So again, contractors, subcontractors, just beware of that. Next slide, please. So they're the sort of key processes in NEC. As I say, there's very, very little in JCT around programming. Typically, you would have some form of programme sewn into the contract, not always, and quite often it will be a pretty vague programme, not what I would refer to as a sort of baseline against which you can necessarily measure delay. And then that, from my perspective, causes a whole load of problems if you get into a dispute, the territory of a dispute over time, because you haven't got a programme that you can base a claim on, whereas in theory with NEC you should, and you should have all that sort of historical background as to how the project progressed through the updated programmes. So in terms of reasons for delay, so this is thinking about risk. So, and generally speaking, what we need to bear in mind is that a contract will set out who bears the risk for certain things within the contract. What I've tried to do is sort of separate it out here. So generally speaking, in a contract, any action or inaction by a contractor that causes delay, obviously, contractor, subcontract, or a subcontractor will not get an extension of time for that. in reverse, third bullet point, any delays to the contractor's progress caused by the employer or somebody acting for the employer will, generally speaking, entitle the contractor to an extension of time. But then there's that mid ground, so the second bullet point, and these are the events that are neither the contractor nor the employer's fault. And these are usually the areas for negotiation and the areas to be careful of. The other two are generally, taken as, taken for granted as to how they fall in terms of risk. But these sort of mid events, so we're talking like things like ground conditions, because, the ground conditions are, in theory, as a concept, nobody's fault. They are what they are. Weather, force majeure. So, we saw that with COVID. Those types of events. Oh, delays caused by third parties, so people not employed by the employer, not employed by the contractor. Those third party delays. It's sort of up for negotiation as between the parties as to how that risk falls, who bears the risk for it, which is, really why the contract is so important. So if we can move on to the next slide, please. Sorry, we're staying on this slide, but we're going to come back and sort of compare how the NEC shares those risks as opposed to JCT. So why do contracts have delay provisions? Well, effectively, the kind of key clauses in a construction contract are what work is going to be done, for what price, and when is the work going to be completed. So, completion is one of the key provisions, and it's key for both parties, because the employer wants access to the facility that is being built by the date that was planned. Equally, the contractor wants to be able to leave site by the planned date, because it has priced on the basis of being on site for that period. So the completion date is really important and is generally included in the contract, so the parties will agree it. If it isn't, then it's time is at large, which means that the contractor is allowed a reasonable period of time to complete. Now, we all, will have had experience of provisions that are supposed to be based on reasonableness. It causes a fundamental problem if the parties cannot agree what was a reasonable period of time, then one of them is going to be going off to adjudication or court to find out what the adjudicator or court considers a reasonable period of time. So you're kind of starting further back than you should have, or that you would have if you had a completion date. And then, of course, we need that, because if the project gets extended, both parties are suffering loss. It's a lose-lose, because the contract is on site longer than it budgeted for, and also the paying party isn't able to use the facility and is probably suffering some losses somewhere down the line, because it's got to rent premises or make contingencies. So that's fundamentally why delay is so important in construction. So if we can move on to the next slide, please. Thank you. So all of the contracts, so we're talking about JCT and NEC here, have grounds for contractors extension of time. So that's whose risk, who bears the risk for the different grounds. Obviously, they are all subject to amendment, and we're seeing NEC being heavily amended in the way that JCT is. Both contracts contain mechanisms for the parties to follow. So that's basically a process. What do you do, the day that you find out, or the day that you think that the project is going into delay for whatever reason? And then, of course, what we need to be careful of is, the real trend at the moment, conditions precedent, these sort of killer clauses that say, if you don't do something procedural, so in this instance, it's usually notifying the other party that there's a delay. So, it's all it is telling them. If you don't notify them, then you lose your entitlement, your remedy to extra time and extra money, which is why I call them killer clauses, because, they are pretty harsh, but the courts will uphold them. So if we can move on to the next slide, please, Jen. Okay, so JCT contract, the grounds for the extension of time. So, well, first of all, under JCT, in contrast to NEC, we have a quote for a compensation event, and that covers the actual cost of the work. It covers the extension of time and also the contractor's cost of time. And of course, because it's an extension of time, it relieves the contractor from any delay damages or liquidated damages. In JCT, we have a variations clause, so that's changes to the works. We also have grounds for an extension of time. Oh, sorry, there's a typo here. So they are in the Design and Build 2016 at clause 2.26. They'll be at slightly different clauses for different JCT contracts. Then also ignore that second line where it says grounds for EOT. It should be relevant matters. So that's at clause 4.21. Of the JCT Design and Build. So basically you have three areas that you've got to look at: the changes or variations clause, dealing with any change instructed. The grounds for the extension of time are clause 2.26, and the money relating to the extension of time is at 4.21. So you've got to check the three areas of the contract. The mechanisms for the EOT, again, clause 2.24 to 2.29. And for the loss and expense, the relevant matters, clauses 4.19. Gosh, this is a terrible slide. 4.19 to 4.20. So if we can move on to the next slide, please. In contrast, NEC 3 and 4, it's fairly simple. We've got grounds for the extension of time, put that in inverted commas, clause 60. Grounds for loss and expense, ditto. Grounds for extra money for extra work, ditto. So it's all there in clause 60. The mechanisms, clause 61 to 65. So that's our process of notifying the CE that we looked at 2 months ago, notifying the CE, providing the quote, getting the quote implemented. Do note, though, that acceleration isn't included in there. That's at clause 36. Next slide, please. So in terms of the grounds, so this goes back to this issue that I was talking about of risk. Who bears the risk for contractor default, contractor caused delay, employer caused delay, and that sort of mid stuff, the neutral bits and pieces that we looked at: ground conditions, weather, etc. So with JCT, there's a bit of a compromise. You might get an EOT, but you don't always get loss and expense. With NEC, you always get all three. You get your money, your time, and the time-related money if you have suffered loss or lost time. Now, note that in terms of these amendments that we're now seeing to NEC, quite a lot of them are using it to kind of adopt, sorry, that sort of compromise situation that we have with JCT. So quite often what you see is an amendment that says, for these compensation events relating to site conditions, weather, force majeure, there may be others, the contractor is entitled to time, but not any money relating to time. So it relieves the contractor of paying delay damages, but they don't get their own costs of being on site for additional time. It's a negotiating point, but of course it's not what is intended in NEC. NEC, as we've seen, compensation events where you want more time, heavily dependent upon the programme or to some extent the works information. So if we, just bear in mind the duty to mitigate, the bottom point. And then if we can go on to the next slide, please. So this is, so this sort of sets out how JCT deals with things as opposed to NEC. So pink is NEC, the bottom line. JCT is the top two lines. So NEC has one line because, of course, as we know, all we have is a CE. So if you have a CE, unless it's amended, you get your extra money for the extra work, you get extra time if you've suffered a delay, and you get your money regarding the time. So that's for contractors and subcontractors. Whereas, as we've been discussing, we've got two lines in green for JCT. One, as you can see on the left-hand side, is if you get an extension of time. The other is you only get, you don't get loss and expense, you just get the extension of time. So second one along in green, it says VO for EOT and loss and expense. So if there's a variation, so basically client changes the works, then if you suffer delay, you get an extension of time. Yep. And you also get loss and expense. That makes sense because, of course, it's absolutely caused by the client. Weather is different. So whether you can see you get an EOT, but you don't get any loss and expense. A change. So third column along where it says not applicable for both the green, that's the ground conditions. So it says not applicable because there is no reference to ground conditions in with JCT, and generally the general rule is that the contractor's got to build whatever it is committed to building, whatever those ground conditions. So essentially, contractor takes the risk of ground conditions in JCT. So no extension of time, no loss and expense, unless there's an amendment. The next one is statutory undertakers causing a delay. With JCT, you get an extension of time, but not the loss and expense. So that's that compromise. And it took, that's that third party causing the delay. Provisional sums, we don't have them in NEC, so that's why that's not applicable. But you get an extension of time and loss and expense where there's any delay caused by a provisional sum in JCT. Next one along, impediment by the employer or others. Again, it's employer cause. So under JCT, you get time, you get an EOT, and you get your loss and expense. Final one, FM, force majeure. So in that one, it's a neutral event, so you get your extension of time, but not loss and expense. So hopefully that shows you how it's sort of subdivided in JCT between the employer-caused issues, where you get your EOT, loss and expense, and the sort of more neutral events not caused by the employer, where generally you just get an extension of time. In contrast to JCT, where unamended, you get both. So if we can move on to the next slide, please. So very quickly, the JCT mechanisms. So this is the mechanism for claiming liquidated damages. So this is for the employers in the room. Some preconditions. There's very little apart from payment certificates really to do under a JCT in terms of submitting documents through the project. But if you want to deduct liquidated damages, first of all, you've got to have issued a notice of non-completion at 2.28 of the contract. You've also, so this is the next bullet point, 2.29.1.2, got to issue, so the employer has to issue a notice stating that it will require the payment of the LDs. Further notice at 2.29.2.1, basically calculating the LDs, and then it needs to be deducted via a pay less notice. So quite onerous. I think the key thing there is if your employer, the paying party under a JCT, you just need to get all your ducks in a row here before you deduct those liquidated damages to avoid it being challenged. Also, if an extension of time is granted, then you've got to reissue the notice of non-completion to state when it applies from, and obviously reimburse any liquidated damages that might have been paid for that period. So if we can move on to the next slide, please. So these are the mechanisms for a contractor applying for an extension of time. So the first bullet point is 2.24.1, contractor has to issue a notice of delay. Now, the key thing here is it has to be issued forthwith, so that's immediately, where a delay is reasonably apparent now or in the future. So if today on a JCT project it becomes apparent to you that either there is a delay or there is going to be a delay in the future, today arguably is the date that this notice needs to be served. The notice, second bullet point, has got to state the material circumstances and the cause or causes of the delay and identify if it's a relevant event. So basically a relevant event, is it a variation? Is it the weather? Is it ground? Well, no, it wouldn't be ground conditions. Is it statutory undertaker, etc.? Then a further notice, a contractor's details of delay has to be submitted as soon, as above, so it can be submitted with the above notice or as soon as reasonably practicable afterwards. So that's 2.24.2. This notice, it's submitted later because it says in the bullet point below, you've got to give particulars of the expected effects, an estimate of any expected delay in the completion of the works or section beyond the completion date. So a bit more information to be provided. Also, 2.24.3, there's an obligation on the contractor to kind of update the above. So I would suggest, if that's your responsibility, you should probably be diarising that monthly to keep updating. So if we can have the next slide, please. Okay, so moving on to the mechanisms for the loss and expense. So this is clause 4.19 and 20. Very, very similar to what we've looked at. First notification 4.20.1, notify the loss and expense as soon as the effect of a relevant matter on the regular progress or the likely nature and extent of any loss and expense becomes or should have become reasonably apparent. And then at 4.20.2, the further notice stating the sums incurred, etc., should be provided. And then 4.20.3, that sort of regular update to notify how it's going, basically. Next slide, please. So once you have notified your loss and expense, it's over to the employer. So the employer under 4.20.4 has 28 days from the initial assessment and 14 from the subsequent notifications to basically respond and say, yes, I'm awarding loss and expense. No, I'm not, or how much is being awarded. So if we can move on to the next slide, please. So the mechanisms under NEC, we're looking at clauses 61 to 65. So we've pretty much looked at these a couple of months ago. So first of all, CE notification by the project manager or contractor, clauses 61.1 and 61.3. So this is just a notification that there is a CE, whether it's the ground conditions are different, some bad weather, force majeure event, change to the scope by the project manager, stroke client not complying with the requirements in the programme, whichever one it is, one of the parties has to notify. And because the implication of not notifying from the contractor's perspective is that it won't be entitled to any remedy, so no time, no money. It's probably best that the contractor notifies if it becomes aware of anything. Then contractor has to submit a quote within 3 weeks of the project manager requiring it, and that's clause 62.3. Project manager then has to reply within 2 weeks as to whether they agree it, want the contractor to review it and based on something different, or whether the project manager is going to make its own assessment, in which case, that latter point, the project manager then has a further 3 weeks to make the assessment. So as we've already seen, delay and the cost of delay has to be included. So that's kind of very, very quickly the NEC process, which, as I say, we covered in detail a couple of weeks ago. Bear in mind the Northern Ireland Housing Executive case, which where the contract talks about the delay being prospective, and of course it is, because of course you are submitting your programme in support of the delay, usually as a quote, so a forecast of the delay that you think you will anticipate, that you will encounter, and that is the basis on which the project manager should assess it, i.e. on the forecast. But of course, we also have the Northern Ireland Housing Executive case, Northern Ireland case, which basically said that by the time disputes get to court or get to adjudication, we've probably finished the project. So we actually know in reality how much delay has been caused. We don't need to rely on the forecasts provided through the project. So the court, the adjudicator, can look at the actual delay, so that's usually retrospectively, rather than the prospective forecast of delay. So, you know, we've got a little bit of an anomaly here, but at the moment, that's what the case law says. So, you know, when you get to adjudication, you might actually be looking at the actual delay. I mean, you know, I'm not a programmer, obviously, and I know it's very complex and very technical, but it seems to me that if you have the programs that have been provided throughout the project, it should be possible quite easy. Well, it should be quite easy actually to work out what the actual delay was in hindsight, as a, you know, in contrast to the forecast prospective assessment of delay. So it shouldn't, what I'm saying is, to me, it shouldn't be too onerous to comply with this as regards programs. I think it's more onerous as regards the quantification of claims, because it requires you to have the documents to show what the actual cost was. But that's not what we're dealing with today. So if we can move on to the next slide, please. Okay, so looking at a delay claim sort of as a sort of fundamental under a construction contract. So this would apply to JCT, it would apply to NEC, a bespoke construction contract. So you're looking at, if you're looking at a delay claim, you are looking at critical delay. So something that impacts on the completion date. So we're looking at critical delays throughout the project, and the particular issue having impacted on the completion date, because of course not every delay impacts on the completion date. I would say, there's a lot of delays on construction projects, depending on the project, I guess, where you can have a delay, but it doesn't impact on the critical delay. In terms of, delays that occur, as a matter of fact, what has caused the delay? The second point is, after that, whose risk is it? And we've covered that where we saw the chart dealing with JCT and NEC. There's also compliance with the contracts, the notices that we've looked at, and the provisions generally, and then assessing how much is due, and also assessing the amount of the delay. And then finally, the general obligation doesn't have to be in the contract, but a general obligation on the contractor to mitigate the delay if possible. So next slide, please, Jen. So disruption, so where we were saying a delay has to be critical delay, so it impacts on the completion date. Disruption, as it says on the first bullet point, it's defined by the Society for Construction Laws, that's the SCL protocol, as a disturbance, hindrance or interruption to contractors' normal working methods. So it says, second bullet point, probably not that helpful to you, but good to know, I think. It's usually obvious on site, but difficult to prove, because what you are claiming is for the additional cost over and above the planned resource. So you're looking at what caused the disruption, because if the contractors caused their own disruption, so as opposed to critical delay, it's its costs to sort it out. Whose risk is it? The point we've looked at. As it says there, it usually doesn't cause critical delay, which is why it's often difficult. It's often, as to whether a party has suffered disruption, it's often a sort of matter of almost common sense, explaining what happened, and why there was the disruption and what you had to do to deal with it. And because of that, you often have to show, so this is the third bullet point from the bottom, what you'd planned to do and the resource, and to show that that was adequate. So you're not, just so that it's absolutely clear that the contractor's not saying, oh, I was disrupted, I had to bring 2 extra people onto site, whereas the reality was what they had planned was never realistic. They only ever had 3 labourers on site and 5 were always required. So yeah, how did the work proceed? And the final bullet point, because this is difficult to prove, records are key. I mean, to be frank, with any dispute, records are key, but particularly here, the people who, well, just, what was planned and was it adequate? You need records to show what was planned, before you can actually prove that you had to bring additional resource on over and above what you'd anticipated. Also the reason that you had to bring them on, etc. So if we can move to the next slide, please. So yeah, you often see reference to global claims. So what is a global claim? Well, that could be a situation where you bring a claim for delay regarding numerous causes of delay or disruption. So basically you're saying this project cost me X, my fixed price, for example, is less than that. And therefore I'm claiming the extra because of the delay and the disruption. So hopefully you can see that's not a particularly bulletproof type of a claim, because basically, there are there could be holes in such a claim because, of course, fundamentally, you might have priced the work incorrectly. The work might not have been done as efficiently as it could have been, etc. So all sorts of reasons, which is why, everybody, sort of shock horror, you can't bring global claims. So generally speaking, that's probably right. Where they do tend to be successful is where there is huge default on the part of the paying party, but either no default on the part of the contractor, stroke subcontractor, or very little, so that you can almost hive off any default of the contractor or subcontractor and say everything else is due to the paying party. If it's a mix of both parties, then global claims are pretty tricky. So if we can move to the next slide, please. So yeah, Keating, which is basically the key textbook on construction law, defines global claims as where you have an inadequate explanation of the causal nexus between the breaches of contract and the relevant events stroke matters. So you can't just say, we had bad weather that entitles us to an extension of time. And it was during this period, so this is the critical delay that it caused. It might be that you've got lots of different causes, but all down to, or all at the risk of the paying party. So next slide, please. Okay, so looking at the Walter Lilly case, this is Walter Lilly and Mackey. Can't remember what date it was. I think it's about 2015, 2014, 2015. So basically, this case is useful if you're a claimant, and particularly, so if you're a contractor claimant, subcontractor claimant, particularly for JCT, because it was on a JCT. But it basically allowed global claims in the circumstances that we've looked at. It was pretty easy on the claimant contractor as regards issuing notices, and took a fairly common sense perspective on it, and basically said, assuming the contract administrator knew that there were delays or that there was going to be loss and expense, the court wasn't too bothered that a formal notice might not have been submitted. If there were minutes of meetings warning about it, that was sufficient. So that's why I say it's a fairly common sense approach. So if we can now just be aware that I don't think that would work if you said, I've missed my 8 weeks under NEC 3/4 for notifying a CE. So, let's use a common sense approach and, say I didn't need to notify. I don't think that would work. So, just be warned about that. So yeah, if we can move to the next slide, please. Okay, and I think the final issue to deal with today is concurrent delay. Again, if you've been involved in a delay dispute, it's often raised, and it's actually amazing how often, when you see the definition, you would think that you wouldn't come across concurrent delay very often, but it is amazing how often you do come across it. So it's defined as when no work is possible on site for a week. So this is an example. Not only because of exceptionally inclement weather, so that's a relevant event, but also because the contractor had a shortage of labour, not a relevant event, so not something that the contractor can claim an extension of time for. So that is concurrent delay. It is a specific period of time where you have two causes of delay. One gets an extension of time, one doesn't. So which one prevails? So if we can move on to the next slide, please. Thanks. So, yeah, so we can move on to that. They're just further definitions which kind of amount to the same thing. So, oh, actually so this is a quote from this Walter Lilly case that I referred to earlier. So actually I said 2014-15, it's 2012. So basically, the court said here that with JCT, in that situation we looked at, whether is an extension of time, contractor default isn't. What the court said was that JCT entitles the contractor to an extension of time if a weather event occurs. There is nothing in JCT that says, oh, but if another event occurs that is the contractor's risk, they don't get the extension of time. So on that basis, under Walter Lilly, they said, yes, you would get your extension of time if there was a concurrent delay. Now, if we go to the next slide, please, because subsequent to that, so of course, ignore this slide for the time being. Don't move it, Jen. If you think about it, so that's a 2012 case. Just park that for the time being. And we'll come back to it. But we also have, just to add extra confusion, the case of Citian and Shepherd, which is a 2010 case, but this is the Scottish law. So in Scotland, they look at things differently. So they have a dominant cause, which is the cause of the delay, and if there's no dominant cause, then they have apportionment. So with our weather and labour, what the court would have to do is decide which was the dominant cause. Was one dominant over the other? And if there was, then that one prevailed. So, I suspect in our example, a court might say, well, the lack of labour was the dominant cause, in which case, no extension of time. Sorry, contractor. If the court couldn't decide or didn't think there was a dominant cause between weather and the labour, then there would be no dominant cause, that second sub-bullet point, and they would apportion. So typically what they would do would be to either apportion the time, to basically apportion the time between the two causes. So if we can move on to the next slide, which I think... Right, we'll just move on from that because we've pretty much covered that. Yeah, move on from that. Can you tell I'm looking for a case? Here it is. So if you remember, we had the Walter Lilly case 2012, 2017. This case, North Midland Buildings and Sidon Homes, came to court. So bearing in mind, we have our determination in the 2012 Walter Lilly case that if you have a relevant event and a contractor event that have both caused delay at the same time, the relevant event gets the contractor the extension of time. What they'd done in this contract was to put a clause in the contract that said any delay caused by a relevant event. So you're going to recognise this scenario by a relevant event, e.g. weather, which is concurrent with another delay for which the contractor is responsible, e.g. contractor's lack of labour, shall not be taken into account when assessing a claim for an extension of time. So that's basically kind of drafting speak for you don't get an extension of time when you have that kind of concurrent delay. So the aim of that drafting was to defeat the finding in the Walter Lilly case. And basically it went to court for the court to determine whether it was a valid clause that could be included in the contract, and the court said yes, it is. So you will see, I can guarantee, because I'm seeing it a lot now, and have been for the last few years, clauses like that being put into contracts, basically saying if there are two events, no additional time or money where one of those events is caused by the contractor. So just be aware of that. And the next slide, please. Yeah, next slide. We'll skip over FIDIC. So, yeah, how can you minimise the effect of delays? I mean, being aware of them at the time is always, really helpful, just from a practical perspective, because it means that if you're aware of it, you can think about how to mitigate if possible. But also, from a disputes perspective, it's just getting records, records to show where the project is at any one point in time. So, records, photographs, programs, but also implement the contract provisions that we've looked at and notify delays. Don't try and sort of keep it hidden or think, well, I don't want to annoy anyone, so I won't issue. The contract's saying, notify. And of course, generally speaking, if you're a contractor or a subcontractor, the type of contract that you have entered into will have been dictated usually by the paying party. So effectively, they are saying to you, we want you to follow this contract, and we therefore want you to notify. So I think if we can move on to the next slide, I think that's everything. Oh no, yeah. So what? Yeah. So if there's a dispute over delay, we've talked about that in terms of programs. But also don't forget the Society of Construction Law, so the SCL, we've looked at this already, has a delay and disruption protocol, which is often useful, talks about the various methods of delay analysis. Obviously, with NEC, you'd have to take into account the Northern Ireland case and the prospective, retrospective issues that we've looked at. But also, there's a tendency to think that a delay analysis is sort of, some very techie thing. But in reality, it is all dependent on the facts and to an extent, a little bit of common sense. So if we can have the next slide, please. So